Okay, I've got a great trivia question for you today. In a medical malpractice case where you have two competing medical experts that go head to head, and they both have excellent credentials, who and how does the jury believe one expert or the other? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. This happens often in medical malpractice cases. Each side will bring in well-qualified medical experts. And now, looking at the doctor, based upon his appearance, based upon his credentials, each doctor sounds as if what they are saying is correct. So we, as the plaintiff, as the injured victim, put on our medical expert, and he sounds very believable. Now, after we're done with all of our proof, the defense brings in their medical expert. And now the jury listens to that expert. And that expert is also well qualified, presents himself really well, and is very believable. So now the jury has two competing medical experts to evaluate. The jury has to determine for themselves which one of the experts they believe. Now, can they believe both experts? No, because they contradict each other. One says there were violations from the basic standards of medical care causing injury, and the other one says no, everything was done appropriately, and the injuries are not the result of anything the doctor did or didn't do. So you have two competing doctors, competing interests, one for the plaintiff, one for the defense. And now the jury has to try and figure out which one of these doctors do we believe. They can't believe both. Then if they can't reach a decision or they view it equally, 50-50, then they're required to give a verdict in favor of the defense. But if our medical expert, together with our testimony, if we are able to show that we are more likely right than wrong by just the slightest amount, then the judge will tell them at the end of the case that the jury is obligated to give a verdict in our favor. We don't have to show with 100% proof that what we are saying is correct. We don't have to show that 75% what we're saying is correct. Just ever so slightly more than 50%. That's all we have to show. So now it comes down to credibility. Who does the jury believe? Does the jury believe our medical expert? Does he present himself well? Is what he is saying true? Does what the doctor is saying make sense? If the answer is yes, now our expert's credibility is going to weigh more than the defense's expert. And in that instance, the jury will then be obligated to give us a verdict in our favor. So why do I share this great information with you? I share it with you just to give you a sense of what goes on in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.